Good morning, everybody, and welcome back to Family Law Assistance. How are we doing this morning? Today, I'm coming with a slightly different live. I'm coming with you because, look, most of the time we talk about children, but here's the thing. People who are going through any kind of child matters or occupation order, non-mol, any application under family law often comes with the caveat that you've probably been married, and if you've been married you've probably got finances to consider. Now, I get it, okay? Finances are nowhere near as sexy to talk about or eye-catching or headline grabbing than contact with the children. I totally get that, but we're coming up to Christmas. Finances and divorce are a real thing. People are separating sooner, so the number of divorces that we're certainly seeing and dealing with are increasing, and sadly I got a feeling that's going to increase. Lockdown is having such a massive pressure on absolutely everybody, and usually if there were cracks in a relationship prior to COVID and lockdown, they're kind of showing themselves up right here, right now. So a lot of people are considering separating, considering divorce. And listen, traditionally it was always January that couples divorced, but we're seeing that brought forward a bit sooner now, which is sad, but I'm not surprised because it's a sign of the times. So today I'm bringing you the quite not so sexy. We're talking about money. And if you're going through a divorce, I just first of all want to caveat that if you are having to deal with finances, and spoiler alert, okay, it doesn't matter whether you've got nothing in the marriage, I would urge you to just to get the finances sorted out and ratified in a court order. Reason being is that not a lot of people know this, but if you don't get your finances sorted out, it leaves you open. You don't sever those ties from your partner, ex-husband, spouse, wife, until you have the finances sorted. Now, actually, the divorce process is the easy process. Getting divorced, honestly, is more of a paper exercise. What takes the time often is finance and children. So today we're going to be talking about finance. So the first thing that you should be taking into consideration is the children. Now, in any financial dispute, whether it's following divorce or whether it's in any other capacity, the court will always have first regard to the children's welfare. Children's welfare is paramount, which you've probably heard, especially if you've been in child contact cases. You will hear that a lot. So money follows the children. It's the rule of thumb in any financial dispute. Money follows the children. So if we've got all your assets and liabilities, we're putting that in a big pie, then usually the primary carer, or the person that has the children the most, is usually going to get a bigger slice of the pie. Why? Because money follows the children. So regardless on where you're at, whether you're resident parent or non-resident parent, it's just something for you to consider. The other thing you want to consider is whether the children have got any special needs. Because look, common sense is going to dictate that any children that have got additional needs, they're going to get a greater share of the pie. Similarly, if the children are young as well, if the children are young, then again, it's common sense. They're going to require more as a toddler than those are older. Now, courts, generally speaking, tend to bend over backwards to make sure that the children's needs are met. Now, sometimes that means that the courts will bend over backwards if they can to make sure that they're in what you'll get to know as former matrimonial home. So the family home, essentially. If the children have been raised in the family home, the court's first consideration will usually be to try and maintain the children's stability and routine. So if you're the primary carer and you want to remain in the property, the likeliness is that the court's kind of going to agree with you because the children. if you are the non-resident parent, my advice always is get the children arrangement sorted first, because having the child arrangement sorted first will have a massive impact on the finances. It's a bit like putting the cart before the horse. So make sure, if you're certainly, especially if you're a non-res parent, that I would urge you to get the child matters sorted. So the second thing that we always consider is age of both of you. Because if you've been, if you're very young, and if it's a very young marriage and both of you are pretty young, then you have the opportunity to kind of rebuild your life post-divorce. Challenges occur when there's been a long marriage and both of you or one of you is older. So if one of you is, for example, in your 50s and your ex is, say, in your 30s, I don't know, I see it all here, then the person that's going to be older, well, more consideration will be needed to take into the older person, because, well, they're going to struggle more so than somebody that's going to be younger. Now, of course, this is broad stroking because one size doesn't fit all, but it's going to be a consideration. And by the way, if you want a bit of nighttime reading, you want to check out section 25 of the Matrimonial Causes Act 1973. The top tips that I'm giving you pretty much coincide with section 25 of the Matrimonial Causes Act 1973. So these are not exhaustive, but they're just the top 5 things that I think that anybody considering divorce should absolutely pay attention to. Number 3, length of your marriage. It goes without saying that as you mesh emotionally, you're going to mesh financially as well. And the longer that marriage continues, the more financially meshed you're going to be. So if, for example, there is a 20-year marriage, then obviously the court is going to have everything in the pot and look at everything. If there's a shorter marriage, whilst there's usually, and I caveat that with children aside, then often people get out what they put in, because you're not that far down the line to be emotionally meshed. Number 4, occupation. Now this is massive, and this has been very controversial. The courts will look at your occupation, the occupation of both of you. Now, traditionally, so certainly longer length marriages, generally speaking, there's been the case where the wife has been the caregiver and the husband has been the provider, the breadwinner. And there's a famous case, check it out, White v. White. It was a landmark yardstick case. And out of that case, it determined that the wife's contribution as the caregiver, the homemaker, was just as important as the husband. So if you're the main breadwinner, you can't really so much get away with the, well, I provided everything, the other party didn't provide anything. But occupation is really important, because especially if one party has been the primary caregiver to children, as we've gone along, then usually their career has been put on hold, whilst the other person has probably flourished in their career or certainly been able to earn throughout that duration. So I could just, sorry, I just having these pop-ups and I can see Stephen. He's so useful, isn't he? Stephen, thank you. So what you've noticed is that Stephen's putting some really useful links. So we've got the case of White v. White for you guys to check out. So occupation is super, super important. Post-divorce, the rule of thumb, the ideal really, is that both parties are able to continue their lives just as they did before a divorce. Now, in reality, that doesn't translate. One has to cut one's cloth accordingly, and it doesn't always work out that way. But taking an occupation into account is a consideration that the court is going to have to make. And number 5, now I'm throwing this in because it's a little bit controversial. Hello, we're family law, it's all controversial. But number 5 is conduct. Now, conduct is controversial. Now, generally speaking, every case, certainly every case that comes through into child contact will always have allegations of abuse, always. So you can guarantee that when one party has left the other, well, let's be real, you wouldn't have left your partner if you thought that their behaviour was hunky-dory. Conduct is absolutely a fundamental factor of Section 25 of the Matrimonial Causes Act. It is something that the court is going to look at. However, it comes with a huge caveat. And the caveat is that courts don't take as much into account of conduct as you might think. Now, there's lots of new laws out there, especially when we're dealing with matters such as coercive control, emotional and domestic abuse, all of that umbrella that will head under abuse. And even with that in mind, for the rights and wrongs of it, the courts still don't really take into account the conduct. Now, that conduct, of course, can absolutely have an impact on the finances. So when you're thinking about conduct as a factor to, well, this is why I need what I need because of my ex-partner's, my ex-spouse's conduct, just have a word of warning. Finance is finance. So if you are going to rely and use conduct as a reason or a factor that you really want the court to look at, then I would make it as relevant to your finances as possible. Now, believe it or not everybody disagrees over finance. I know. We certainly here at Family Law Assistance advocate getting conciliation going, getting agreement going. Trust me when I say that things work a bajillion times better if both parties agree. So if you are in that situation where, you know what, you'd have normally just kind of agreed things over a Costa coffee, brilliant. And if that is you, I'd urge you to get a consent order put together and send it off to the courts with the relevant forms. If, however, you are in dispute, then the first thing I get you to do is, first of all, know what you want. Always know what you want. The amount of people know what they don't want. People don't often know what they do want. So if that is you, know what you want and go to mediation first before sending in your form. And it's a Form A, by the way. Guys, I hope that has been of use to you. If you are needing any help, as usual, holler at us and we will help. Any questions you want, put in the comments below. Hope you found this useful. Have a great day. Over and out.